Yes, Ms. Paul.
Good morning, my lady. May it please the court, I appear for the respondent defendant in this action, URS Corporation Ltd, together with my learned friends, Mr. Hannah and Mr. Reed. My learned friend, Mr. Hargreaves, King's Counsel, and his junior, Mr. David Sheard, appear for BDW Trading, the appellant claimant in the action.
Yes, thank you. Now, before you get started, Ms. Parkin, first of all, I do appreciate it's very warm in here. We think we've turned the knob in the right direction. We hope that it's currently working, but we really will try and make the room cooler for all of you, so I'm sorry about that. But no doubt your submissions are going to be so scintillating there's no danger of anyone dozing off, Ms. Parkin.
Well, my lady, all I can say is that if members of the court drop off to sleep, I shall put it down to the temperature in the room.
Now, we're grateful for all the material we have. We're very grateful also for having had the core bundle of authorities. We've all three of us had an opportunity of reading extensively into this matter, including diving into the relevant, the key authorities. As you know, the matter is currently listed for 3 days. My lord listed it for 3 days really as a safety net at a time when we really weren't very sure quite how long everything would take. Our current view is probably that is an extremely generous estimate. No doubt you're carving up time between you, but I think we're feeling that probably a couple of days ought to do it, but we're not putting any pressure on you if you tip it to a day.
Well, I'm obliged, my lady. Maybe if I could just give your ladyship an indication of where I think I'm going to go.
Certainly, that's most helpful.
And potentially one area, which in my learned friend's skeleton, he's highlighted as potentially waiting for the court's decision on what I might call substantive matters, and whether the court's any view about whether it wishes to hear everything all in one go, or whether it wants to hive off. And perhaps if I can explain the matter thus. I think, as the court knows, this is an appeal from 2 or 3 orders, in fact. The first being an order of Mr. Justice Fraser dated October 2021, which is an order arising out of some preliminary issues which were ordered by Mrs. Justice O'Farrell, and a strikeout application. And it's secondly an appeal from 2 orders of Mr. Williamson, King's Counsel, sitting as a Deputy High Court Judge, made in November 2022 and December 2022, in which he gave my learned friends permission to lift a stay, which had been imposed pending the determination of Appeal 1, and also permission to make various amendments. The amendments, as I'm sure this court knows, arise out of the coming into the force of the Building Safety Act 2022, and there are a number of issues which arise in relation to what we might loosely call the retrospective effect of that provision. It is my learned friend's submission that if I get to the point of persuading this court that Mr. Justice Fraser got it so wrong that this court should strike out BDW's claim, it would wish the court to reserve on the strikeout matter pending determination of what I understand to be his Section 135 arguments. I'm entirely in the court's hands as to whether it wishes to hear me on everything and my learned friend on everything, or whether it's formed any view about whether the Section 135 matters should indeed be deferred to a later date.
Just give us a moment. Do you want to twice for a moment, just to talk that through? Excuse us a moment.
No.
Yes, we'd slightly anticipated something may be said, but to confirm what we thought. Yeah, at the moment, our present view is that the 135 can be hived off.
We're obliged.
And I think, as you will have gathered, also from the reasons my Lord Justice Coulson gave in his when he granted permission to appeal, we feel the heart of this appeal centres around ground 2 in any event.
I'm obliged for that as well, my lady. in my respectful submission then, just to give you a route map through what's
Please,
about
that's very
to
helpful.
happen,
No, that would be most
if I
helpful.
might put
Thank
it in
you.
those terms. I'm going to start obviously with the first appeal, and
Yes.
I'm going to explain to the bench why it is that we say that Mr Justice Fraser got the answers to the preliminary issues wrong, and that the answers should be no, no, yes and yes, for reasons which
So we
will
finished
become
now.
which will become apparent as I hopefully go through my submissions. The reason that we say it should be no, no, yes and yes is that we say that URS's duty to BDW was limited in two respects. It was a duty to protect against damage to the proprietary interest in the building that BDW held an interest in, and it was a duty to protect against claims made against BDW in relation to damage to the building sorry, let me start again. Duty to protect BDW against claims made by third parties arising out of damage to the building. We say neither of those risks came to fruition. In short, BDW sold the building for full value, and no claims have in fact been brought against BDW. Instead, and as BDW accepts, and I'll show the bench in a moment why I say this, it accepts that it incurred its losses in order to protect its commercial reputation, but the judge found that URS owed no such duty, and the result of that is that the claim in our respectful submission should be struck out. So that's the scope of duty, which one might say goes to the heart of ground one. Scope of duty points also crop back up in ground two, which is the point in time at which a cause of action accrued. BDW had identified three such points in time. The first point in time being the completion of the building. Second point in time being the date upon which it incurred liabilities to third parties, which I understand to be the date upon which it entered into the contracts of sale with purchasers. And the third point in time being the point in time at which it discovered the defects and carried out the remedial works. What I'm going to do with your ladyship's permission is go through each of those heads, so each of those three grounds, and explain why it is we say that none of those work. And in relation to the third ground, namely the accrual of the cause of action in 2019, that will inevitably involve returning back to the scope of duty point. So in that sense, there is the interplay between ground one and ground two of the appeal. Having done that, my lady, we will turn next to the amendments applications. As the court will know, my learned friend made an application and was granted permission to make three sorts of amendments. The first were amendments to the existing negligence claim. Now, we say that if we are successful in our appeal on the existing negligence claim, the amendments made to the existing negligence claim are irrelevant because the claim will have been struck out by the court. And as my learned friend, Mr. Hargreaves, explained to the deputy judge, the amendments he seeks to make don't go to cause of action, but only to what we might call quantification issues. So we won't spend much time dwelling on what I might call the first ground of the amendment application. The second ground of the amendment application is the ground whereby my learned friend seeks to raise DPA claims. It is the respondent's submission that the DPA claims are gifted to it by the coming to force of the BSA. Our submission is that no such claims lay regardless as to the coming to the force of the BSA for two sorts of reasons. Firstly, my learned friend as a developer is not a person to whom a duty is owed under the Act. And secondly, even if he is a person to whom a duty is owed under the Act, the losses which flow from a breach of the Defective Premises Act can only ever flow in the direction of a person with a current proprietary interest in the property. That is not the respondent. Now, I've also got some Section 135 arguments about the DPA, but in the light of the observations from the bench first thing, I'm going to park those for later on. Finally, that brings us round to the claim for contribution made pursuant to the Contribution Act. There is what I hope is a relatively short point in relation to the Contribution Act, which is, we say, in order to bring a claim under that Act, it is necessary for my learned friend to have identified an up-the-line claim, if I can call it in those terms, namely a claim made by, in normal circumstances, the claimant, which if one envisages a normal contribution case, one would have a claimant, defendant 1, defendant 2. Defendant 1 will be passing down the claim from the claimant to the second defendant. In this case, not only is there no claim from a claimant, but no claim has been made, and we say that is fatal to a claim under the Contribution Act. And again, there are all sorts of Section 135 points which arise in relation to the Contribution Act, but I won't be touching those today. So that's the route map of where we're going to go. I'm going to move relatively swiftly, subject to any questions the bench has got, because there's a fair amount to cover, as the bench will appreciate. So, returning to the beginning,
yes.
And the negligence claim. Sensible starting point in my respect for submission is to look at the statement of claim. My lady, that can be found in the core bundle at tab 22. Just pausing to note that this is the amended particulars of claim. So this is the particulars as it stands post the decision of the Deputy Judge Williamson in December last year. The amendments are pretty straightforward to follow, so I'm hoping, just for simplicity, to stick with the amended pleading rather than to refer you back to the pleadings that stood in front of Mr. Justice Fraser.
That seems sensible, thank you.
In the normal course of events, we can see what comes in and goes out through the red lining, see the red and the striking through. The first point to note, my lady, my lords, is if you could turn on pleads to page 208. The description of the developments. There are two developments with which this case is concerned: Freeman's Meadow, and if one turns over the page, at page 209, one sees Capital East development. Pausing there, just in terms of Capital East, to note that Capital East consisted not just of flats but also of commercial space too. Returning back to page 208, one will see there the plea that URS was appointed to provide structural engineering services in connection with the development as set out below, and a similar plea at paragraph 5. Moving swiftly on to the contracts themselves, which are important, obviously, at page 211. Paragraph 8, by contract in writing dated the 10th of March 2005 between BDW and URS and executed as a deed, a copy of which is appended here too, URS agreed to carry out the services, BDW agreed to pay URS the fee. 9 and 10 describe what those services are, or some of those services in broad terms. And then on to 213. the usual implied term. And then paragraph 12, which is obviously of some importance in these proceedings, the duty of care plea. URS owed a duty of care to carry out the services with all reasonable skill and care so as not to cause BDW to suffer loss, including pure economic loss. URS having assumed responsibility for the performance of those services and BDW having relied upon such performance. I don't believe it's controversial, but the assumption of responsibility in this case clearly comes from the contract itself. This is a concurrent duty case in a Henderson merit type situation, and we'll come on in a moment to look at what the contract actually provided for, because in my respectful submission, that is of some significance in terms of the duty itself. That's Freeman's. Capital East, we're in slightly different territory. You can see that if you turn on to page 214. You'll see that there's a contract there of unknown date, and the reason for that is that nobody could find the contract, presumably because it was so long ago it's got lost in the midst of time. But you will see at the bottom of paragraph 16 the plea that it's likely to have contained terms which are the same as, or materially the same effect as those set out in the Freeman's Meadow appointment. So for the purposes of my submissions, we will proceed on the basis that Freeman's Meadow, the terms of the Freeman's Meadow appointment are the terms that would govern Capital East as well, if the parties could lay their hands on that document. The contract itself, and my ladies, my lord, is at tab 24. And with the court's permission, there are a few features of this which I think are relevant to the submissions I'm going to make about scope of duty. My ladies will see it's a contract dated 10th of March 2005. Page 270. One sees the definition of the development. Paragraph 1.6, a definition of something called the relevant period, of the relevance of which we shall look at in a moment. The court will note there that that's the period of 12 years from the date of practical completion, or if earlier, 12 years from the termination of the provision of the services. Now that may be of some significance, not least because the date of practical completion of a development is likely to be significantly later than the date upon which a structural engineer last provided its design services. So one might say there that the relevant period is already providing for the structural engineer to owe certain duties or obligations for a significantly extended period of time. The services themselves are defined in clause 3, which starts at page 272. One notes at 3.3 the warranty, the contractual warranty that the duties are going to be carried out with reasonable skill and care and diligence. But then over the page at 273, clauses 3.10 and 4, the first hint really about what this contract is in my respectful submission really concerned with. Clause 3.10 provides for the consultant to enter into collateral warranties in favour of the first tenant or first purchaser, including without limitation a purchaser of a leasehold interest for a premium, or person providing funding for the development, and shall execute any such collateral warranty within 21 days of the employer's written request for it. The form of the collateral warranty is annexed to the agreement, and the employer will specify at the time whether or not the italicized wording is required. Consultants shall not be required to enter into collateral warranties in favour of individual residential occupiers. So 3.10 provides for the situation in which Barratt is selling its freehold interest in the development on to a purchaser, or in which it's seeking funding from a third party, and 3.10 says, if I do that, if I sell on, you, the engineer, will provide a collateral warranty to the person to whom I sell on to. Clause 4 is entitled NHBC documentation and provides what it was that URS was going to have to provide for the purchasers of the flats. You'll see there, my ladies, my lord, the employer will wish the development to have the benefit of NHBC, Zurich or other insurances, as the employer may select, for the benefit of its occupants. The consultant shall provide such assistance certificates and other documentation as the employer may reasonably require in order to enable the selected insurance protection to be available to the prospective occupants of parts of the developments at the times the employer wishes to exchange contracts with them for the sale or letting of the part of the development in question. So 3.10 and 4 in my respectful submission provide in express terms for what was to happen on the sale of the development by BDW to various forms of purchaser. Whether that's a purchase of the entire freehold interest in the property or a purchase of one of the flats. BDW required URS in both circumstances to provide documentation to those purchasers which would ensure that those purchasers had their own remedies available were there problems with the development. Just picking up a couple more clauses in the main contract, 276, professional indemnity insurance. The URS warranted that it would hold professional indemnity insurance to the minimum cover, which in this case was £10 million, for the entirety of the relevant period, which, as we saw a moment or two ago, was 12 years post practical completion. On to 277, assignment. URS couldn't assign without the prior written consent of BDW, but at 12.3 we can see that BDW may assign or change the benefit and or the rights under and or arising from this agreement by giving written notice to the consultant. So again, BDW could choose to assign all of its rights to a third party under this agreement if that was what it wished to do at a later stage. And just picking up very quickly the collateral warranty which URS agreed to give to future purchasers. Starts at page 285. At 286, 1.9 relevant period. Again, one sees that 12-year period referred to. .1, exercise of skill and care. The warranty which URS agreed to provide to those to whom the benefit of the collateral warranty attached. Clause 4 at page 288. Again, the provision in relation to insurance. Clause 6 at page 289. The ability of the beneficiary under the warranty, without the consent of URS, to assign, but no more than twice, the benefit of the consultant's obligations under the deed. So again, in the world in which I operate, fairly standard provisions of a collateral warranty, but again, in my respectful submission, indicative of the arrangements that these parties agreed to enter into in 2003. And in my respectful submission, what one sees when one looks at this contract as a whole is the fact that this was not a case in which URS agreed an unending liability to BDW in relation to defects in this building. What it agreed was that it would ensure that those who took on the building after BDW divested itself of it had the protections provided for under this contract. Now, importantly, this is a BDW standard form. We'll come back to that when we come to look at ground 3 of the nature in which the full of the cause of action is said to have eventuated. If we can turn back to the pleadings to highlight the way in which the cause of action debate arises. Just skipping through, if we can start, we were at paragraph 12 at page 213 of the core bundle. Capital East, as we've already identified, is dealt with separately, and one sees the implied term and the duty of care at common law set out at paragraph 17, page 215. Where the learned pleaders simply repeat what they've said in relation to Freeman's Meadow. On to 216. Heading D, the design defects. These are pleaded out between paragraphs 22 and 41. These are all defects in the underlying design. There is no plea that these defects caused damage to the building.
My understanding, Ms. Parkin, is this right? This is taken from the judgment, is that following the tragedy at Grenfell, there were investigations. One of the blocks that was investigated was called Cityscape. Although happily there were no cladding problems, a separate structural issue was identified which had caused cracking. That then led to further investigations of other blocks, including these, but there was no physical damage in relation to the blocks with which we're concerned.
That's almost right, but not quite, my lord. If I could explain, your lordship will see it at page 216, paragraph 22.
216, paragraph
22 describes the circumstances in which what happened was, your lordship's absolutely right, Cityscape, which is an entirely different development, designed by an entirely different party, i.e. not by URS.
Right.
Was, during the course of taking off the cladding, the defects were discovered in the floor slab, and that floor slab had cracked, as a result of which, you'll see, my lord, if you go on to page 217, a wider investigation was instigated by BDW in relation to designs carried out by the group of companies in which URS is a part and the city-state.
So the correction to my summary is that Cityscape was not URS.
No, absolutely.
But was, as it happened, the trigger for the investigation.
Cityscape was the trigger for the investigation, and the investigation ranged far and wide, and as a result of the investigation, these defects were discovered in the designs of these other different developments.
Yeah.
But both Cityscape and the blocks with which we're concerned were designed by companies within the AECOM group.
Absolutely, my lady. Just
That before they merged, though.
I'm so sorry, my lady.
At one stage, one of the designers wasn't part of the group, but subsequently became part of the group.
So effectively, what we're looking at is a consolidation of the structural engineering industry across the UK over the early 2000s. Middle-sized engineering companies of the sort which designed Cityscape and indeed which designed these two blocks were swallowed up initially by URS, which is a large American corporation, and then in 2014 URS was taken over by AECOM.
That's what
And
I
so
understood.
hence why these are all part of the AECOM group of companies.
Right.
But at the point in time of the design, they were individual.
Okay.
It's a bit like the solicitors' consolidation that we
Yes.
see these days.
But
So-
that's the one qualification to the summary.
Absolutely, my lord, yes.
Thank you.
I think we were back in, I was explaining to the court that effectively these designs, the designs and the developments that we are concerned with are said by BDW to be defective to the extent set out in these particulars. As a result of which, and then there is a plea, if my lord, your ladies, be good enough to turn on to page 226. Section E of the pleading. Capital East structural defects, that's the defects in the design, and the Freeman's Meadow structural defects in the design, and each of them constituted and/or were the result of URS's negligence. And then we see the pleas in negligence. And just for the court's note now, we'll come back to it later on, at 46A you see the plea there as well, that effectively the designs also gave rise to, or are said to mean that these properties were not fit for habitation. 227, loss and damage.
I appreciate that it's obviously relevant to the second part of the appeal concerning with the amendment, but so far the allegations in respect of negligence are not themselves amended. So the duties stayed the same, the breaches have stayed the same.
Absolutely, my lord.
Is this right? The amendments are relevant to what BDW say their position may be vis-à-vis claims by third parties,
Not quite, my
which is in the reply.
Not quite, my lord.
Okay, so what's when you talk about the amendments to the allegations of negligence, what are those?
Oh, I see. I'm so sorry, my lord. Yes, those are in the reply, and those are amendments to a case
Because you have
about.
to search quite hard for the reply.
It is
It's in supplementary bundle volume 2,
It is, my
tab
lord.
something or other, but I retained the
go
will
there.
to live and I found it. So that's why I say those look to be the amendments that they're concerned with, that we are concerned with, the Deputy Judge was concerned with. So I just wondered what else was relevant to when you talk about the amendments to the negligence case.
There are some amendments to the further information. There are two sets of further information.
I haven't gone that far.
Well, my lord, we will have to go into a little bit of further information, but hopefully not too much.
Right.
They are amendments to a case about how one goes about, if one gets to the stage that there's a duty and a breach of duty, how one assesses causation, remoteness,
Okay,
and
fine. Well, you can
mitigation.
take us to that. That's helpful.
I'm just looking at Mr. Hargreaves. I'm not intending to mischaracterise those. But
No. That's very helpful. It's just that because there were no amendments actually to the particulars of claim, that was all I was anxious if I'd missed them. But they're in the further information, so that's fine.
They are, my lord.
Yep, that's fine.
I'm sure Mr. Hargreaves can give you the references if your lordship should require them. But for my purposes, I'm not intending to go to those amendments.
Yeah.
So we got the breach of duty. We're now looking at the loss and damage, which is section F of the pleading. Page 227. Now, there are a variety of heads of loss and damage pleaded here. I'd invite the court to just skim through them for present purposes and to note at 228 that the reputational damage at 48.7 is struck through.
Because of the judgment of Fraser J.
Of Mr. Justice Fraser, and there's no appeal before this court in relation to that finding. The pleading starts with capital East, but effectively Freeman's Meadow replicates the heads of loss claimed in relation to Freeman's, which one sees in capital East. Just before we leave this document, because it's worthwhile picking it up now, 231. One sees the heading G, contribution. Now, at that stage, the plea was this. Further, if and insofar as further payments are made by BDW in due course, which would attract a right to a contribution from URS and or Cameron Taylor, BDW intends to claim such contribution from URS and or Cameron Taylor in these proceedings. So a stated intention to claim something which happens subsequently. What in fact happens, as the court will note if it looks at 49 and 49A through to C, is that the contribution which is now claimed is in relation to the same heads of loss and damage as were always in the pleading. And we'll come to look at that when we look at the contribution claim. Tab 23 is the defence. Which I'm hoping I can deal with fairly briefly. The relevant pages at page 238 and 239. Paragraph 9 makes a limitation plea. Paragraph 10, secondly, and in any event, and this is the important bit for these proceedings, BDW has no accrued cause of action in tort, having suffered no actionable loss by reason of any of the alleged breach of duty. And then paragraph 10 goes on to explain effectively that because it had sold its proprietary interest for full value and hadn't been the subject of any claims, there was no actionable loss. And at page 239, paragraph 10.5, makes the express point that reputational loss was not within the contemplation of the parties. Leading to 10.7, URS will contend that because loss is a necessary element of a cause of action in common law negligence, no cause of action has arisen or could ever arise because BDW was and is not liable to incur costs in relation to the alleged defects and is not liable to the third parties in respect of the same. So that is the defence putting in issue the matters with which this court is concerned with today. The response to that defence one finds in the reply, supplemental bundle tab 2, tab 29, and again, my ladies, my lord, I'm taking the court to the amended reply. For ease, effectively, but if the court's interested in finding the actual reply that was in issue before Mr. Justice Fraser, that's in Supplemental Bundle Volume 1, Tab 4. And again, we can start, if it pleases the court, at page 364. Which is BDW's reply to my defence, which is limitations in issue and you don't have a cause of action. Paragraph 5 deals with the position in relation to limitation. We're not concerned with that. Paragraph 6, however, is relevant. and that is the reply to the plea in the defence that BDW has no cause of action. And 6.1 says this: it's admitted that BDW no longer has any proprietary interest in the blocks, which are the subject of the litigation. It's denied BDW has suffered no actionable loss and or has no accrued cause of action in tort. And then 6.2 sets out the 3 cases in relation to which it is said that a cause of action accrues. 6.2.1, when each of the defective blocks was constructed. 6.2.2, when third parties acquired an interest in the dwellings in the relevant blocks, at which point BDW incurred a liability to those third parties for the alleged defects pursuant to Section 1.1 of the Defective Premises Act, and then right at the bottom of that paragraph, and or individual contracts of sale. And when we come on to look at that head of BDW's claim, in my respectful submission, it will be important that we distinguish between claims made pursuant to Section 1.1 of the Defective Premises Act, or potential claims that might have been made, and claims arising out of individual contracts of sale. We'll come on to that in a moment. And then finally, at 6.2.3, yet further or alternatively, when the existence of the defects in the design became known, resulting in the losses claimed by BDW in respect of the same. And for these purposes, I'd be grateful if the court would just ignore the bits in red because they weren't before Mr. Justice Fraser at the point in time that he came to determine the preliminary issue. Now, we asked for some further information in relation to that pleading, and I'm afraid we need to go back to Supplemental Bundle 1, tab 5. And I'm interested in request 2, which starts at page 56. What you'll see in the request which follows is the same request made under each of those subparagraphs of the reply that we've just identified. So the first one arises out of paragraph 6.2.1. So the plea, as you will recall, is BDW suffered damage when each of the defective blocks was constructed in accordance with the negligent designs. And the request is, please provide particulars of the nature and type of damage which BDW asserts it suffered in relation to each of the defective blocks at the point in time when each of them was constructed. And the answer is there. The nature of the damage which I suffered when the defective blocks were constructed was that, and this is what is said, damage having arisen because the blocks contained defects which would, but for URS's negligence, not have existed. The alleged defects have not, to BDW's current knowledge, caused separate physical damage. So it is said there, I have a cause of action when I construct the blocks to your design, which is defective. So that's the first manner in which BDW puts its case. As to the second manner, we need for these purposes to turn on to page 57. Actually, one sees at the foot of 56 the setting out of paragraph 6.2.2 of the reply, and then again at paragraph 5 right at the top of page 57. Please provide particulars of the nature and type of damage which BDW contends it suffered and which is said to have given rise to an accrued cause of action against URS and Cameron Taylor at the time third parties acquired an interest. And the answer to that request can be found at, this is a slightly oddly numbered document, but as I think has been noted on every occasion in which we've been before a court, but it's to be found at paragraph 4. which says this: as to request 3.5, and then A repeats the primary case, and B says, when the dwellings, so it suffered, the nature and type of damage suffered is that when the dwellings in the defective blocks were transferred to third-party purchasers, BDW suffered damage because it incurred a liability pursuant to individual contracts of sale and or Section 1.1 of the Defective Premises Act, which, but for URS's negligence, it would not have incurred. So that's the second way of putting the case. And then if we turn over page 58, we see the same request being made again of the third way in which BDW put its case. So this time we're looking for paragraph 6. Please provide particulars of the nature and type of damage which BDW claims it suffered when the existence of the design defects, the alleged design defects, became known. And the reply to that starts at the foot of page 58 there, as to request 4.6. And then if we turn over, one sees A, the repetition of the primary and secondary case, and then B, this plea, which we do attach some importance to on this side of the court. Without prejudice thereto, when the existence of the defects became known, BDW suffered damage, since it was at that point subject to financial loss. The result of the defects is that the structure of the relevant blocks was unsafe. If BDW had refused to act to address the defects and compensate owners who were impacted thereby, it would and or could have suffered significant reputational damage and consequential economic loss resulting therefrom. BDW has reasonably incurred or will reasonably incur the cost of rectifying the defects and meeting costs that would otherwise have been incurred by owners in respect thereof, which mitigates the prospect of such loss. So the plea there is we incurred it to protect our reputation, in a nutshell. So these are the three bases upon which it is said that the cause of action crystallised. What did the judge find? Mr. Justice Fraser found for BDW on its primary case, and one can see that at paragraphs 108 to 110 of his judgment, and for those purposes we're back in the core bundle at tab 12. At page 165. Can I just invite the court to read those three paragraphs, which will give the court
Sorry, it's 108 to
108 to 110.
Thank you.
Thank you.
So the judge finds that the cause of action accrued on the date of practical completion. Now, the reasons that he finds that are discernible if one goes right back into the body of the judgment, starting, in my respect for submission, at paragraph 80, page 158 of the bundle. Under the heading "the date when the damage occurred."
This is all under that heading.
It is, my
80
lord.
to 118 is all under the heading "the date when damage occurred."
It is, my lord. And what Mr. Justice Fraser does is he starts by analysing what I might call the traditional building contract cases of Pirelli, Murphy, New Islington, Abbott, with which I know at least one of the members of the court is familiar.
I'm a lot more familiar with them than I was 48 years ago.
Well, I suspect you're about to become even more familiar than that, my lady. So this is the judge starts by going through the authorities which, to a number of us in this court, are very familiar. And then when one gets to paragraph 91 at page 161, he moves into a consideration at 91 all the way through to 107 to a consideration of authorities which I'm going to loosely call transaction-based authorities for reasons that will become apparent in a moment. And concludes that by happy coincidence, whether one does it by reference to the building authorities or the transaction authorities, all roads lead to Rome, and the date of the cause of action is the date of practical completion. And he takes some comfort from the fact that whichever way he does the analysis, the answer is the same. Now, in my respectful submission, the problem with the judgment, and in particular the part of the judgment which deals with the building authorities, is a confusion which runs right through the entire section of paragraphs 80 to 90 of the judgment, and is perhaps best encapsulated by the final sentence in paragraph 83 on page 159, where the judge holds latent damage is damage the physical manifestation of which is not present. Now, with the greatest of respect to Mr. Justice Fraser, in my respectful submission, what the judge is doing there is confusing a number of different concepts. In particular, the authorities establish, and we will come to look at them in a moment, that there is a distinction between a latent design defect which for present purposes I'm going to define as a defect in design which has not physically manifested itself in damage. So there is no physical damage. So on the one hand, one has a latent defect, and then on the other, there is the question of latent damage. That is when a latent defect has manifested itself in some form of physical damage, but the physical damage is not yet known about by the owner of the building. So Pirelli, which we'll come to look at in a moment, is a case about latent damage. There was a defect in the design which caused cracking 2 years after the building had been constructed, but the damage wasn't discovered by the owners for some considerable period after that. It was common ground before Mr. Justice Fraser, and indeed it's common ground before this court, I think, that we are not a Pirelli situation because there has been no physical damage. As a result of which we say the authorities on latent damage are simply not relevant. what then is the answer to this question, where one discovers the latent defect before it has caused the damage? Two propositions were put to the judge. The competing propositions, which as I understand it, are before this court. My proposition, which I say is supported by high authority in the House of Lords in Murphy and Brentwood, and the authority in this court, Abbott and Will Gannon, and various Commonwealth authorities, which we'll come to look at in a moment, is that if the parties discover a latent defect in design before it causes physical damage, a cause of action would have crystallised at that point, because as the authorities show, it's at that point that the economic value of the building is affected.
Because then suddenly you know that you have a building which isn't sound and therefore is worth less than a building which would be sound.
Yes, absolutely. So one can no longer go about dealing with the building, transmitting it on to third-party purchasers as if it was not defective, effectively. You know that the building suffers from a defect, as a result of which its value diminishes then and there. Now, that was our respectful submission to Mr. Justice Fraser and again in this court. The problem for BDW with that approach is that, of course, that analysis focuses on the economic value of the building itself. BDW, at the point in time that it discovered the defect, no longer had any interest in these properties whatsoever. So this wasn't a case in which BDW's proprietary interest in the building could be said to have been affected.
Leaving aside that point, which obviously is important, that's no different to BDW's tertiary case.
Well, it is for that very reason.
Well, but leaving aside that, it's the same because it says discoverability.
Well, it's the discoverability that causes the damage, if I can put it like that.
But that triggers the cause of action.
Absolutely.
That's when the cause of action crystallises.
Yes.
So, from a crystallisation point of view, that is the same as BDW's tertiary case.
Exactly.
But you then go on to say, but that doesn't help BDW because they'd sold the building.
Exactly.
Understand?
So that was what we were submitting to Mr. Justice Fraser and what I am submitting to this court now. Against me, it was said that the damaging consequences of the defective design were immediately apparent as soon as the building was constructed. So that the cause of action accrues on practical completion or at the point in time that the structural designs are incorporated into the building, at which point Mr. Hargreaves' clients had a proprietary interest. Now, in order to explain to the court why, in my respectful submission, I'm right and Mr. Hargreaves is wrong, I think we're going to have to now look at some authority. So, without further ado, can we please look at Pirelli, which the court will find in the Joint Core Authorities bundle. Volume 1, tab 3.
And I'm sure that my lady will be running a penalty system for any authority to which either side refer that's not in the two bundles core authorities. I shall be taking a note for my ladyship's assistance at the end.
I think my lord's just trying to cover up the fact that he told us that we didn't need to read any authorities that weren't in the joint authorities bundle.
That is, of course, another way of putting it.
A negligent misrepresentation on the part of Lord Justice Coulson. I'm going to do my best to stay within these
You
bundles.
must, of course, take your own course and be happy to look at anything you wish us to.
My learned friend and I actually did do a little bit of work to try to reduce the mass.
It was extremely helpful.
Yes.
But I certainly from my perspective, there are one or two that I am going to have to go to.
That's absolutely
and I
fine.
suspect my learned friend as well. Anyway, for current purposes, we
anticipated.
are in the core bundle.
Now, if I might just put away.
And Pirelli, you accept, is not directly relevant.
I accept it is not directly relevant because Pirelli was a case which concerned physical damage.
There were cracks.
Absolutely, my lady. But the important thing about Pirelli is that it's important for the court to see the sorts of arguments which were put before the House of Lords and why it chose to accept some and not others. Because in my respectful submission, what we're about to see from Pirelli and the other building authorities is that building law has taken a very different course in terms of accrual of cause of action from what I might say the sort of transactional professional negligence cases that this court might sometimes see and be concerned with. And the answer as to why that is effectively that, and it's described I think by Lord Lloyd in Invercargill, in building cases, although of course we describe it as economic loss, it's not really pure financial or economic loss because it is concerned with a defect in a building. You are thinking about a physical thing which has been affected by the negligence, design or building, which is different from an abstract transaction.
You'll have to take me particularly to the passages that you think are of assistance with that, a distinction, because I, at present, just to tell you, I don't understand it. Because if you design, well, let's talk about anything. You're not going to design a tomato, but if the tomato inherently has something wrong with it and so it is going to explode at some stage, it's an exploding tomato from the very beginning.
But my lady, it might assist if one goes right back to Donahue and Stevenson and the ginger beer and the snail in the bottle.
That's why I revealed my my position, because you may have to go back a long way.
Well, I'm Donahue and Stevenson is one of the very few authorities which is actually not in the bundle, my lady, but I'm sure we can get hold of it over the short adjournment. Your ladyship might actually be assisted by looking at Pirelli and seeing.
Yes, exactly. That's why I was
what Lord Fraser
trying to warn you in relation to what's said in Pirelli. That's all.
If any of what I'm saying to your ladyship is I'm not making myself clear, perhaps your ladyship and I will do my best to try to make patent what is latent, if I can use that terminology.
Don't use latent, please.
So, Pirelli, as we know, defective chimney, cracks in the chimney, and at the point in time that Pirelli is decided by the House of Lords, the important point for my Lady Justice Asplin and my Lady Justice King to note, I suspect Lord Justice Coulson knows this, is that Pirelli was decided when a case called Annes and Merton was still good law. And Annes, Lord Wilberforce in Annes, had described damage to buildings as physical damage. We'll see in a moment how Murphy changes the position. One starts, if one may, at page 12. When one sees just above letter E, the nature of the contentions that were made to the House of Lords in Pirelli. So one sees this. The respondents maintain that the judge came to the right conclusion on the matter and that the action is not time barred. The appellants maintain that the cause of action accrued more than 6 years before the writ was issued. They suggest 3 possible dates of accrual. The earliest suggested date is that on which the plaintiff acted in reliance on the defendant's advice to install the chimney, which was bound to be defective and eventually to fall down unless previously demolished. They did not fix this date precisely, but it must have been between March and June 1969, well outside the limitation period. The second suggested date is that on which the building of the chimney was completed, namely July 1969. Pausing there, one of those 2 cases is my learned friend's primary case in this action, namely that the cause of action was completed upon the construction of the building in accordance with the design. And then the third date, which is contended for by the appellant, is the date on which the cracks occurred, namely April 1970. He says these 3 dates are all more than 6 years before the issue of the writ, which, as I already mentioned, was October the 17th, 1978. If any of them is the correct date, the action is time-barred. Lord Fraser then goes on to talk about the development of the Limitation Act and decisions of the Court of Appeal in a case called Sparham Suitor, and the House of Lords decision in Cartledge and Jopling, which I'm sure is familiar to the court in terms of when a cause of action in tort accrues and the need for some damage to have been suffered before before a cause of action crystallises. And Lord Fraser goes through the authorities at pages 13, 14, 15. And then at the bottom of page 15, from letter F onwards, he deals with a case called Sparham Suitor, in which the Court of Appeal had found that a cause of action where a house is built on defective foundations does not accrue until the time as the plaintiff discovers the bad work had done damage, or with reasonable diligence ought to have discovered it.
The battle was between Cartledge and Jopling and Sparham Suitor. Cartledge and Jopling when damage occurred, and Sparham Suitor when it was discovered.
Absolutely, my lord, is the difference that the court is identifying there, and one can see that. If one turns over to page 16, and then again, a passage on which again I place some reliance at letters just above letter C. My lords, I find myself with utmost respect unable to agree with that argument. It seems to me that there is a true analogy between a plaintiff whose body has, unknown to him, suffered injury by inhaling particles of dust, and a plaintiff whose house has, unknown to him, sustained injury because it was built with inadequate foundations or of unsuitable materials. Just as the owner of the house may sell the house before the damage is discovered, and then these important words, and may suffer no financial loss, so the man with the injured body may die before pneumonia cocognosis becomes apparent, and he may also have suffered no financial loss. In both cases, they have a damaged article, when but for the defendant's negligence, they would have had a sound one. And then again, he refers to the X-ray analysis example given by Lord Pearce in Cartledge and Jopling. And then letter F, he explains why he thinks the Court of Appeal got it wrong in Sparham Suitor. I think, with all respect to Geoffrey Lane, or just as Geoffrey Lane, that's in Sparham, that there is an element of confusion between damage to the plaintiff's body and latent defect in the foundations of a building. Unless the defect is very gross, it may never lead to any damage at all to the building. It will be analogous to a predisposition of natural weakness in the human body, which may never develop into disease or injury. The plaintiff's cause of action will not accrue until damage occurs, which will commonly consist of cracks coming into existence as a result of the defect, even though the cracks or the defect may be undiscovered and undiscoverable. He then goes on at page 18 members of the bench.
The rest of that paragraph is the
It's the
doomed
doomed from the start analysis, which had...
Well, it's not an analysis, is it, with respect?
It's,
I mean,
no, well, I don't know.
it's simply an identification that there may be circumstances where the building is doomed from the start, but in any event that wasn't relevant to the chimney in Pirelli.
It wasn't relevant to the chimney in Pirelli. In fairness to my Lord, Mr Justice Fraser, there is a hint that he thinks that a doomed from the start analysis might be relevant here. However, that was a contention for which neither party had advocated in front of him, and as I understand it, neither party is advocating before this court. So there are the authorities...
We may have to look at it, though.
Well...
When we get to it, we may have to look at it with great respect. I understand the points between the parties, but I mean, it's always been a very odd concept, but in circumstances where, in this case, we're talking about something that's unsafe, it may not be irrelevant.
No, indeed, my lord, and indeed there are the authorities in here. There's the case of Ketman and Hansel, in which the House of Lords expressly took on the sort of proposition which your lordship has just put into me, and if we need to, we can go through that authority at the relevant point in time. For the purposes of these submissions, my lord, though, I'm not intending to address your lordship, my ladies, on the doom from the start analysis, or the doom from the start potential at this point in time, because, as I've indicated, that's not something that I understand either of us is currently contending for. If I need to come back to it at reply stage, I will. So, my lord, Lord Justice Coulson is right to say that at the bottom of page 16 is the hint of the doomed from the start proposal. Now, page 18 is where Lord Fraser deals with the other contentions which have been put before him by counsel for the appellants. And in particular, I'm looking now right at the final paragraph on page 18, just above letter G, counsel for the appellants. Counsel for the appellant submitted that the fault of his clients in advising on the design of the chimney was analogous to that of the solicitor who gives negligent advice on law, which results in the client suffering damage and a right of action accruing when the client acts on the advice. See Howell and Young, a case that's not in the bundle, and Forster and Outred, a case that is in the bundle. It is not necessary for the present purpose to decide whether that submission is well-founded, but as it presently advised, I do not think it is. It seems to me that, except perhaps where the advice of an architect or consulting engineer leads to the erection of a building which is so defective as to be doomed from the start, the cause of action only accrues when physical damage occurs to the building. And then he says, in the present case, this was April 1970, as found by the judge, cracks must have occurred at the top of the chimney, even though that was before the date of discoverability. So, he's asked to follow the start of the transaction cases, namely the analysis adopted by the Court of Appeal in Forster and Outred to building cases. Forster was a case in which Mrs. Forster was entered into a mortgage transaction to guarantee her son's business. Unfortunately, the business didn't quite go according to plan, and Mrs. Forster's mortgage was called upon, and she sued the solicitor, alleging that he did not advise her that her home was at risk if she did not keep up with repayments. The Court of Appeal held that in Forster that Mrs. Forster's cause of action accrued immediately upon entering into the mortgage transaction. The reason for that being that at that point in time she had an encumbered freehold when she should have had an unencumbered freehold had she not entered into the mortgage transaction. So that was the analysis being urged on the House of Lords in Pirelli by the appellants, and it is one which was rejected by Lord Fraser, who holds...
Well, he says it's not necessary to decide.
My lady's absolutely right. He does say it's not necessary to decide, but one can see from the conclusion that he reaches that he cannot possibly have adopted a Forster type analysis, because his conclusion is the cause of action accrues, crystallises when the physical damage occurs.
Yeah. So that makes your case that what is said in Pirelli on this aspect anyway isn't relevant anyway, because this is not a physical damage case.
Absolutely.
But that's why he distinguishes Foster and Utrecht.
We're going to go on and see what happens after Pirelli, at which point, my lord, I hope my submissions will become somewhat clearer.
Speaking for myself, Miss Parkin, they're very clear now.
I'm obliged, my lord. In terms of developments in building law, the next big case from a building lawyer's perspective is the case of Murphy and Brentwood, which the court will find behind tab 10 of the core bundle. Murphy is the culmination of cases stretching right back to essentially Dutton and Bognor Regis back in 1972, which we don't need to look at. But Murphy concerns the liability of a local authority for defects in a building. So Murphy is a 7-man House of Lords panel, and the reason for that is the court was being asked to overrule Annes and London Borough of Merton. Annes had decided that a duty of care in relation to health and safety issues accrued upon the discovery of defects which gave rise to a risk of health and safety of the current occupants. And that duty attached not just to the builder who built it, but to the local authority building inspector who had turned up to inspect the foundations and supposedly certify that they were in accordance with the relevant building regulation requirements at the point of time. Anne's, I am reliably informed, spawned a whole series of litigation which resulted in many multi-party pieces of litigation being held in what was then the official referees corridor, and I understand it occupied large swathes of the construction bar for many years before Murphy brought matters to a shuddering halt. Murphy, then, members of the court, is a case in which, as one can see if one looks at the description of the case at page 398, this was the appeal by the council, who had effectively passed or certified various plans, and one sees at letter E on page 398, the house was built with defective foundations. Whilst the plaintiff was occupying the house, the foundations cracked. Consequently, there was extensive damage to the walls and pipes of the house. Instead of repairing it at the estimated cost of £45,000, plaintiff sold the house for £35,000, less than its market value, in undamaged condition, claimed damages being the difference in the value between what the house was worth and what it got from the local council. The head note reveals what the House of Lords held. I'd like to look at certain of the judgments in a little detail. If I can start, my ladies, my lord, with the judgment of the Lord Chancellor, Lord Mackay, which starts at page 456. Mackay explains why he is content for Anne's to be departed with. I'm going to refer the court to this passage and the passage on the following page for two reasons. Firstly, because it sets up my argument about what Murphy decides for cases of this nature, but also as well because it introduces another theme, which in my respectful submission we see from this case and later cases, about the intervention of statute in the field of consumer protection. And in Anne's, one of the deciding factors in the House of Lords decision, in Murphy, one of the deciding factors of the House of Lords decision to overturn Anne's is that in the interim, the Defective Premises Act had come into force, and we will see various members of the House of Lords stating that in fields of consumer protection, Parliament should be the decider and not the courts. So, Lord Mackay, I'm going to start at letter F. What he does is he identifies what Lord Wilberforce has found in Anne's. And he says this: as I read the speech of Lord Wilberforce, the cause of action which he holds could arise in the circumstances of that case can only do so when damage occurs to the house in question as a result of the weakness of the foundations, and therefore no cause of action arises before that damage has occurred, even if as a result of the information obtained about the foundations it may become apparent to an owner that such damage is likely. So what Lord Mackay is highlighting is the difficulty with the Anne's formulation, which is if an owner knows that it's got a defective building, it doesn't have a cause of action until the defective building manifests itself in some damage. And he says, and we'll see Lord Keith saying the same thing, that that's a slightly unsatisfactory distinction for the law to draw. And then he goes on about a person to whom the duty is owed is the owner or the occupier. And then at the bottom, as has been demonstrated in the speeches of my noble and learned friends, the results of applying these qualifications to different factual circumstances is to require distinctions to be made which have no justification on any reasonable principle and can only be described as capricious. It cannot be right for this House to leave the law in that state. And then if I could invite the court to cast its eye down, one will see the reference to the coming into force of the Defective Premises Act and the impact that Lord Mackay says that has on this area of the law. Lord Keith, who gives, I think, the longest speech in Murphy, that starts at page 458. The first thing that Lord Keith does is he dispels the notion that damage to buildings is physical damage, and he identifies and summarises why the correct view is that the damage is effectively economic damage to the value of the building. And one can see that perhaps if we start at 465. And my Lady Justice Asplin, just for your note, there's a sort of a summary of how we get from Donahue and Stevenson on 464, which your Ladyship may find of interest or note for later reading. 465, having set out Lord Denning's judgment in Dutton and Vulgar Regis, which was the case which started off the Anne's trend, Lord Keith says this: the jump which is here made from liability under Donahue and Stevenson principle for damage to persons or property caused by a latent defect in a carelessly manufactured article to liability for the cost of rectifying a defect in such an article which is ex hypotheosi no longer latent is difficult to accept. A Stamp LJ recognised in the same case there's no liability in tort upon a manufacturer towards a purchaser for a retailer of the article which turns out to be useless or valueless through defects due to careless manufacture. The loss is economic. It's difficult to draw a distinction in principle between an article which is useless or valueless and one which suffers from a defect which would render it dangerous in use, but which is discovered by the purchaser in time to avert any possibility of injury. The purchaser may incur expense in putting right the defect or more probably discard the article. In either case, the loss is purely economic. So that is a move away from the characterisation that Lord Wilberforce had adopted in Anne's, because Lord Wilberforce had said that what was needed was physical damage to the property. And there is Lord Keith explaining that actually it cannot be physical damage for the reasons which I've just read to my ladies and to my lord. And then at 466, he says this just above little letter b, consideration of the nature of the loss suffered in this category of cases is closely tied up with the question of when the cause of action arises. Lord Wilberforce in Anne's regarded it as arising when the state of the building was such that there was a present and imminent danger to the health or safety of persons occupying it. That state of affairs may exist where there is no actual physical damage to the building itself, though Lord Wilberforce had earlier referred to the relevant damage being material physical damage. So his meaning may have been that there must be a concurrence of material physical damage and also present or imminent danger to the health or safety of occupants. On that view, there would be no cause of action where the building had suffered no damage, or possibly having regard to the word material, only very slight damage, but a structural survey had revealed an underlying defect presenting imminent danger. Pausing there, we say that that is what this case is. Such a discovery would inevitably cause a fall in the value of the building, resulting in economic loss to the owner. That such is the nature of the loss is made clear in cases where the owner abandons the building as incapable of being put in a safe condition, as in Batty, or where he chooses to sell it at the lower value rather than undertake remedial work. And then he referred to the decision in Pirelli, which we've just looked at. And he says this between letters E and F. If the plaintiffs had happened to discover the defect before any damage had occurred, there would seem to be no good reason for holding that they would not have a cause of action in tort at that stage without having to wait until some damage had occurred. They would have suffered economic loss through having a defective chimney upon which they required to expend money for the purposes of removing the defect. And then he describes Pirelli as a case which is based on Headley-Byrne principles, namely an assumption of responsibility which gives rise to a duty of care in tort to protect against economic loss. And then right at the bottom of this page, in my opinion, it must now be recognised that although the damage in Anne's was characterised as physical damage by Lord Wilberforce, it was purely economic loss. And then, my ladies, my lord, he goes on to cite a case of Shire of Sutherland and Hayman, which is High Court of Australia. And if the bench would be so good enough to read to itself, page 467 to 468, the analysis which Lord Keith finds as, or describes as, being in respectful agreement with, because the reasoning contained is incontrovertible, one will see that what Mr. Justice Dean in Shire of Sutherland is saying is essentially what Lord Keith has just explained in Murphy.
Do you want us to read that
If
through
you
now?
wouldn't mind.
Certainly.
Reading. So, my lords, my ladies, what one sees from that final paragraph of Mr. Justice Dean's judgment in Shire of Sutherland is that if one approaches this as an economic loss question, economic loss is, as he says, sustained at the time when the inadequacy is first known, that's our case, or manifest. That's the case in which one has a physical defect, because it's at that point that the economic loss is suffered. It is only then that the actual diminution in value occurs. On either approach, however, any loss involved in the inadequacy of the foundations by a person who acquires an interest in the premises after the building has been completed is merely economic in its nature. So that's Murphy, which we say is authority for the proposition that if you discover a latent defect before it results in physical damage, the cause of action accrues at that point, because that's the point in time at which the building suffers economic loss.
So, Murphy's obviously a case about physical damage, so it's as irrelevant as Pirelli.
It is, my lord, but the reason
So
that
it
I'm
doesn't
taking...
decide, it can't decide that. That may be something that along the way is part of the, you would say, part of the reasoning. But Murphy is a case about physical damage.
It is, my lord, but the reason that I'm taking my lord and my ladies to the authority is because it is a case about physical damage. But what Murphy does is it says we're wrong to characterise defects in a building as physical damage. It's economic loss, and the reason that one can test it in economic loss terms is because if one does the analysis and asks oneself the question, if I discover the defect in the design before it's causing damage, do I say I simply have to wait until the damage accrues before I've got a cause of action, or can I at that point sue? Murphy says at that point you can sue.
Yeah. So again, you accept that. Therefore, that means that you don't need physical damage, and you can have a cause of action because there is a latent defect. There is something wrong, and it may be that it's been something wrong from the start.
The defect has manifested itself by being discovered, for example, when one undertakes the structural survey in Murphy.
But it's that point that, because Mr. Hargreaves' primary case is that he had a cause of action because the thing itself was defective.
Exactly.
So the only point then becomes when that cause of action accrues. You're agreed that you don't need physical damage. You're agreed you can have a cause of action if there is a latent defect. The question then becomes when that cause of action accrues. Does it wait until you know about it, or did you have a cause of action from the start?
And in my respectful submission, what Mr. Justice Dean in Shire of Sutherland is saying, cited with approval by Lord Keith in Murphy, is that the cause of action in those circumstances accrues when you discover the defect. Because until then, you're transmitting, if one thinks about it, in terms of a house with the latent defects in the foundations. One can go on selling the house to purchasers without anyone knowing that the problem occurs. But as soon as one knows that the problem occurs, the house becomes worth less than it would otherwise do because you have the problem known about with the foundations.
So it's like saying economic loss only arises when actually the market can discern it.
Absolutely. And In a moment, we're going to look at what Lord Nichols says in a Hong Kong case, which effectively says that, my lady. But before we go to Hong Kong, I'd like to take the court to a case called Abbott and Will Gannon, which is a case in the Court of Appeal in 2005, which is in tab 18 of your core bundle. Now, Abbott is about the cracking to a steel beam in a bay window in a hotel in Torquay. Effectively, it ends up being a rerun of Pirelli because, as the Court of Appeal recognises, it's bound by Pirelli. But the enterprising advocates in Abbott tried to persuade the court that, in the light of Murphy, what we're looking at now is economic loss, and the analysis should be different from Pirelli. The Court of Appeal makes the somewhat plaintive observation. This is Lord Justice Tuckey, paragraph 17 at page 569. Where he notes that there are a number of three House of Lords cases to guide us. It ought to be possible to give a clear answer to this question, but I regret that I feel unable to do so with any confidence. He then goes on effectively to say he's bound by Pirelli. You can see that at paragraph 19 of his submissions. His judgment, I do apologise. And then at paragraph 20, he goes on to consider the position as if he's not bound by Pirelli. If, contrary to what I've said, we're not bound by Pirelli and the claimant's cause of action accrued at the time when they suffer economic loss, I do not accept Mr. Hollowell's submission that this occurred in March 1997. That's the point in time at which the defective design had been incorporated into the building. The defective design, he says, had not caused any loss at that time. It would only do so when it manifested itself in some way which would affect the value of the building, measured either by the cost of repairs or depreciation in market value. In other words, I accept Lloyd's analysis in Invercargill, which, as he says, avoids almost all the practical and theoretical difficulties which cases of this kind have caused. Present case is, I think, the common case where the occurrence of the loss and its discovery coincides. On this view, the cause of action in the present case accrued in 1999. That was when the cracks actually appeared in the lintel and were discovered to have appeared in the lintel. So the claim was not time barred. So again, I accept not this case because there was physical damage, but what the court is doing in Abbott is saying if I have to look at this through the lens of economic loss, then the answer to the question when is damage suffered is when you become aware of it.
When it manifested
Manifested
itself.
itself.
A phrase that obviously one uses all the time.
I'm about to incur my first penalty point by taking the court to a case called Bank of East Asia, which is in Section A, Volume 3. And it's tab 25.
Sorry, tab.
25, my lady. Now, this very lengthy judgment, the court will be delighted to learn that we don't need to go through most of it. I'm interested in the judgment of Lord Nichols at page 362. which is almost towards the back end of the case, maybe 3 pages from the end. Really.
Sorry, hang on a minute. What is this? This is a
This
decision
is
of...
State Church, decision of the Privy of the... Wait a minute, my lord, and I shall tell you. It's a decision of the Court of Final Appeal in Hong Kong.
Thank you very much. So, Court of Final Appeal in HK.
Which, as my lord is aware, is a court in which members of the English then House of Lords have from time to time sat. And I'm interested in Lord Nichols' decision.
Yeah.
I should state at the outset that this is a dissenting decision because alongside the decision of Mr. Justice Bokery, other members of the Court of Appeal, sorry, of the Court of the Hong Kong Court, had adopted a what I might call traditional Pirelli analysis. The reason that I'm taking the court to Lord Nichols' decision is that in answer to a question and an observation posed by my Lady Justice Asplin a moment or two ago about the affecting of the market value, in my respectful submission, what Lord Nichols does is he takes Murphy to its logical conclusion and identifies what the answer would be if one goes the whole hog and says Pirelli is bad law. And it is, in my respectful submission, an enlightening decision. And I would invite the court, if it has 2 minutes now, just to read these 2 pages of the decision.
Sorry, I missed the reference.
It's Lord Nichols at page 362, my lord, which is 3 pages from the back of the judgment. It's tab 25.
362. Well, he doesn't sit on the fence, does he?
He does not, my lord. I think that's a good quality of a member of the judiciary, if I may respectfully say so. But one sees effectively what Lord Nichols is doing there is taking the Murphy decision to what he considers to be its logical conclusion. And my Lord Justice Coulson will know, Lady Justice King, Lady Justice Asplin may not be so familiar with this, but there has been for years a perceived tension, as one can probably see from the authorities, between Murphy and Pirelli. And the question is always asked, well, why didn't they overrule Pirelli and Murphy? The answer comes back, well, they just didn't. Not very helpfully, but building lawyers are, where physical damage occurs, stuck with Pirelli. I'm not inviting this court to depart from it, nor could it. I am saying it's not relevant for the reasons that we have explained. And I'm also saying that if one moves away from the Pirelli analysis into what we say is the appropriate analysis, that analysis shows that the cause of action accrues on discovery of the defect, not when the defect was incorporated into the construction of the building. So far, we've looked at two ways in which a latent defect might cause damage. So we've identified that in Pirelli, it causes latent damage, the cracking, the physical cracking. I've submitted to this court that Murphy is the authority for the proposition that where there is no physical damage caused by the defect, the cause of action accrues upon the discovery of the defective design. Murphy, Shire of Sutherland, Abbott, Lord Nichols in Bank of East Asia. I'm now going to move to the third way in which the courts have held that a latent defect might cause or damage. And that is where it is accepted that the defective design produces physically damaging consequences which are immediately effective on the incorporation of the defective design into the buildings. Now that sounds a bit theoretical. I'm going to put some colour on it by taking you to the case of New Islington, which is back in our core authorities bundle. Everyone can put away the penalty bundles. And just bear with me a moment, my lady. It is in
Tab
it's
13.
the first core bundle, tab 13. Thank you. So, my ladies, my lord, this is a case which, in terms of its chronology in the authorities, sits between Murphy and Abbott. And it's 2001, and it is Mr. Justice Dyson, as he then was, sitting in the Technology and Construction Court. This time, we are concerned with defective sound insulation in flats in Islington. So moving slightly closer to home. Now, if one thinks about sound insulation, just as a concept, one can see immediately that either it works or it doesn't work. And I understand that members of the High Court who sat in the Rolls building when the Rolls building was first opened might well have some experience of that fact. Sound insulation is not something which can get physically worse. It either works or it doesn't, and that becomes apparent pretty much effectively as soon as you've built the building. And indeed, that is what Mr. Justice Dyson held in New Islington. And one can see that if one looks at, starts at the head note, page 515. Where he talks about the nature of the problem, and the fact that these are statute barred because the cause of action accrued effectively upon completion. And then we need to go over to 524, where he starts to consider the negligence part of the case. He sets out at paragraph 28, at the heart of the consideration of the issue lies with the House of Lords decision in Pirelli, which he accepts he's bound by. At paragraph 30, he says that Pirelli has given rise to a number of difficulties in different situations. He refers to a case of Tozer Kemsley. That's in the big bundle. I'm so sorry, it's not in the big bundle. It's behind tab 6 of the authorities. I'm not of the core bundle. I'm not proposing to take you to it because I'm going to summarise what Tozer Kemsley is about. The judgment's there if the court wishes to consider it. Effectively, Tozer Kemsley is about an air conditioning plant which was installed in a building. Problems with its workability had been notified to the building contractor during the course of construction. I think he turned it on, and a bit like this court, it didn't get very cold. Effectively, in Tozer Kemsley, Judge Stab, Queen's Counsel, sitting in the Technology Construction Court, held that where a piece of plant is incorporated into a building and it is defective when it is incorporated, the cause of action occurs on the incorporation of the plant into the building when it doesn't work. So again, one can see there that the physically damaging consequences are immediately effective in the way in which the sound insulation becomes immediately apparent that it doesn't work. And as we can see from Mr. Justice Dyson's decision at page 30, at paragraph 30, he notes that the defect in Tozer did not cause any physical damage analogous to the cracking caused by the defectively designed chimney in Pirelli. At 31, he refers to a case called Dove and Banham's Patent Locks, which is a case about a burglary. I don't think that is in the bundle. Neither of us refers to it. One can see what it says from 31 in Mr. Justice Dyson's decision. 32 is an important case. It's the case of London Congregational Union and Harris and Harris. That case is in the bundle. It's tab 8.
Do you want us to go there?
I'm so sorry. In a minute, we may have to go there, but I'm hoping that I can do it by telling you what it says, or at least explaining to you what I think it says.
So
but
it's
it
tab
is
8.
Tab 8.
Tab 8, if we want to go to it.
London Congregational Union and Harris is about the installation of a defective drainage system in a church hall in East Finchley. The drainage system, the church hall appears to have been built on a hill, and the drainage system doesn't appear to have been designed to take account of the fact that it was built on a hill, with the result that when it rained quite a lot, the drainage system flooded, and the floods affected the church hall, which had been constructed. Now, the years don't matter very much. It tells us here that it tells us in paragraph 32, practical completion of the building took place in 1970. In August 1971, the building was flooded and damaged as a result of the negligent design of the drains. The writ was issued in February 1977. Obviously, if the cause of action accrued when the building had been completed, it was time barred, and if it accrued when the flood occurred, it wasn't. And what the Court of Appeal in London Congregational Union say is that although the drains were defective, and everybody accepted that the defective design had been incorporated into the construction of the building, the drains functioned adequately for the first 20 months or 22 months of the life of the building. So they functioned as drains for the first 22 months of the life of the building, and it was only upon the occurrence of the heavy rainfall in August 1971 that the drains flooded and the physical damage occurred. And one picks that up quite usefully if one perhaps now turns to tab 8 and just reads the headnote.
I might say that there'd been no damage because there hadn't been any heavy rain.
Well, I think
that
there had
doesn't
been
mean that the drains weren't defective from the start.
Well, I think as one sees if one reads the case, in fact, there had been a bit of rain before that date, just not enough effectively to cause the flood. So that they had
difficult cases make bad law.
well. What the Court of Appeal is doing in London Congregational Union is, in my respectful submission, identifying our third category of case, which is where one has a defective design and the damaging consequences were immediately effective. They say that's not the case in London Congregational Union. It is the basis upon which Mr. Justice Dyson finds that practical completion is the relevant date in New Islington. And we say this, one can test it this way, in relation to the facts of our case. These are buildings which have stood now for some, at the point in time the remedial works were done, 15 years, 14 or 15 years, without any physical damage having occurred at all. They therefore, to use the analysis adopted in London Congregational Union, functioned adequately for that period of time. Now, and this is also quite an important point, the reason why the remedial, one might ask at this point, well, why is the remedial work necessary if they had functioned adequately for that period of time? And the answer is that the remedial works were necessary to stop the physical damage or potential for physical damage eventuating at a later stage. So unlike in New Islington, where there was no potential, the sound insulation had manifested itself immediately upon occupation of the building, everyone could hear that it didn't work, literally. In this case, in our case, we have a situation in which these developments have been occupied for 14 plus years, and the work which is being carried out is being carried out to prevent the possibility of future damage. So it's not a case in which no physical damage, it's said that no physical damage could ever eventuate. So we say we are not New Islington and we are not Tozer Kemsley. We are not Pirelli. We are instead the case which Lord Keith postulates in Murphy, in which the defect is discovered before it does damage.
So you are Overton Murphy.
Overton Murphy, if one could call it that.
Is there anybody you actually are?
I'm so sorry, my lord.
Is there anybody you actually are?
I'm me, my lord.
You've listed all the people you're not, all the cases that you're not.
Well, I mean, the honest answer is no. There is no analogous authority on the which is on all fours with the facts of this case, which is probably why it's here, my lord.
Yeah, I mean, I appreciate what you say about Sutherland, and I appreciate what you say about the obiter bit of Abbott, but again, that's obiter.
It is, my lord.
So, there's nobody that you can point to and say, I'm like that.
No, my lord. Well, I mean, I would say that I'm like the people identified by Lord Keith in Murphy.
Yeah.
But I accept that I can't show your lordship a decision in which the people identified by Lord Murphy had brought a case of that nature before us.
And your point of distinction between those cases which are relied on as showing, look, if you've got something that's defective from the start, so it's a latent defect, and therefore the cause of action is practical completion, your point of distinction in relation to that is that those are cases where the damaging consequences of the defect were immediately effective.
Absolutely, my
There was a
lord.
crack in the chimney.
No, my lady. So there are. Shall I summarise by saying
The air conditioning didn't work.
The air
Oh,
conditioning
sorry,
didn't
beg your
work.
pardon. I thought you were going back to
Yeah,
Pirelli.
no,
So
it was-
Pirelli, there
no,
was a crack in the
effectively
chimney,
this-
but the other ones, the air conditioning did not work.
Air conditioning
And the
and
drains
air
worked
conditioning
for a
do
bit.
not work.
Yeah. So you've got three
Drains-
categories. You've got the Pirelli where you've already got your cracks.
Yes.
You've got the situation where the soundproofing was a disaster from the beginning.
Yes.
And then you've got they worked for a bit,
Yes.
and then they stopped,
and then they stopped working. Now,
they stopped working.
London Congregational Union and Harris, I say, is a bit like our case because we've got the working, in fact, for more than 22 months in our case, for a significant period of time. Well, they worked for 14 years, and whereas in London Congregational Union and Harris a flood occurred, and so the damage was apparent, in our case the analysis is that the defects in the design were discovered, and so economic loss accrued at that point to the proprietary interest of the building.
So you say the cause of damage, and the cause of action would only be when the damage occurred. But anyway,
Yes.
you don't get home anyway because
Yes.
you'd all got rid of them. You had no, there was no loss.
Absolutely. I'm noticing a quizzical expression.
And it's all part of what we discussed earlier, which is you say you can only have economic loss when that is recognised, and that can only be recognised when you know about the defect, because otherwise it doesn't affect your market value.
Absolutely, exactly, for the reasons that Lord Nichols so trenchantly explained in Bank of East Asia. Just bear with me one moment, I might have to do another penalty case, but I'm just going to check something. think maybe just for the court's note, rather than something I need to take it to, my learned juniors are highlighting the case of Invercargill and Hamlin, which I have perhaps advertised to you already. Which
That's the one you've mentioned. That's the one where Lord Lloyd is less than complimentary about Pirelli.
Indeed, my lord.
Which tab is it in the appendix
It's in
bundle?
bundle A2, tab 21.
We're happy to look at it if you would like us to.
It's
We're
on-
happy to look at it if you would like us to.
Well, then in that case, I mean, it's a page 648. I'm not sure it's an answer to Lord Justice Coulson's question about pointing to an on all fours authority, but it is yet another example of the approach in terms of economic loss to buildings.
Yes.
I'm sorry, I'm slightly lost. I should be in the ordinary authorities.
Yes, my lady. A2,
Yeah.
tab 21, page 648. Maybe starting at 647, one can see the familiar quotation from Sutherland Shire Council and Hayman set out there at 647 and then on to the top of 648. And then if I could invite the court's attention to see all the way down to the bottom and just over to the top of little a on the next page.
The sideline part.
Indeed.
Thank you.
Sorry, which page again?
I'm on 647 and 648, my lord.
Right.
I've just identified 647 as the start of the quotation from Sheriff Sutherland, and then Lord Lloyd's less than complimentary approach is at paragraph C on 648 down.
Thank you. Thank you, Junior.
So Invercargill and Sutherland are both cases about subsequent purchases of properties that, unbeknownst to the purchaser when they bought it, had defective foundation.
Absolutely, my lord. And one is a New Zealand authority and one is an Australian authority. Yeah. And I know your lordship will be aware that my ladies, Justice King and Asplin, may not be so aware that the Commonwealth authorities have taken a different approach to Pirelli. Some follow it, sorry, to ANZ. Some follow it and some don't. Which is why one has to be a little bit careful when one's looking at those authorities. The reason that I'm showing you that particular passage from Invercargill is that it supports my submission about how one approaches economic loss in terms of the crystallisation of the cause of action if one is going to characterise damage to buildings, as one has to as economic loss, but to move away from the Pirelli type analysis.
Thank you.
So just to summarise then, latent defects per se do not constitute damage sufficient to start a cause of action running in tort. They have to emerge. There are three ways in which they can emerge. Firstly, physical damage. And we can break physical damage into A, latent physical damage, see Pirelli. B, patent physical damage, see the drains in London Congregational Union. Both latent and patent being enough for the starting of the running of the cause of action where one has the physical damage. So firstly, latent defects emerge as damage when there's a physically damaging consequence. Secondly, latent defects emerge as damage if the physically damaging consequences are immediately effective. See our sound insulation in New Islington.
See again?
Our sound insulation in New Islington. and our defective air conditioning in Tozer Kemsley. And the third way in which they can emerge is if the defect is discovered before damage has occurred. The discovery giving rise to or creating the economic loss. And for that I rely on the observations of Lord Keith in Murphy, Lord Justice Tuckey in Abbott, Lord Nichols in Bank of East Asia, Lord Lloyd in Invercargill. And just to close off what is limb 1 of the way in which my learned friend says his cause of action accrues. At the point in time that we say the discovery of the defect occurred, which is 2019, BDW had no proprietary interest in the building. And the reason that that matters is because, as all of the cases, Murphy, Abbott, Invercargill, Bank of East Asia emphasise, it's the value of the building which is diminished, and that is something which attaches to the owner of the building. And as Lord Lloyd says in terms in Invercargill, if one sells the building on for full value, one can have suffered no loss. So that is why we say limb 1 of the accrual of cause of action for Mr. Hargreaves and his clients doesn't work.
And that's the primary submission that goes to ground 2 of the appeal.
It is the primary submission that goes to limb 1 of ground 2.
Yes,
yes.
I mean, you haven't dealt with the secondary and tertiary
no,
cases.
No, I'm just about to do that.
I understand that, but that's the crucial
absolutely
point.
Yes. Now, limb 2, just to remind ourselves of what limb 2 is, so from the further information, first supplementary bundle, tab 5, page 57. Case, we ask provide particulars of the nature of damage of the type BDW contends it suffered at the time that third parties acquired an interest in the dwellings, and the response at paragraph 4b is when the dwellings in the defective box were transferred to third party purchasers, BDW suffered damage because it incurred a liability pursuant to individual contracts of sale and or sections 1.1 of the Defective Premises Act, which, but for URS's negligence, it would not have incurred. Round 2, or limb 2, if I can put it in those terms, is effectively the reliance on the transactional cases line of authority. What's interesting when one starts to look at the transactional line of authorities, which we'll probably do after the luncheon adjournment now, is that whereas the building authorities, when they're asked to follow the transactional authorities, say, no, we've got our own special rules in building law, the transactional authorities, when asked to follow cases like Pirelli, say, we've got our special rules in transaction cases.
The judge didn't make that distinction, though, did he? The judge dealt with the transactional cases, as you call them, using your label. He dealt with the transactional cases under BDW's primary case.
He did.
Because he said that they were consistent.
He did. But they're not BDW's primary case. I don't think my learned friend is suggesting they are BDW's primary case. I think that what the learned judge is doing, or what I had understood him to do, is to say that he takes support from the approach that's adopted in the transactional case. I think that's what he's doing.
Yes, and it was my understanding that Mr. Hargreaves also derived support for
he
his
does,
primary case.
He does, my lord, he does.
Okay, but you're going to deal with them. That's a convenient way. What you're saying is, I say this is effectively reliance on the transactional cases, so that's the convenient place to deal with them.
Absolutely, and I'm using, as I hope the court appreciates, transactional in a very loose
I understand that.
sense,
Yeah.
and I'm obliged, because as we'll see, some of the cases don't actually involve transactions at all. Right, so the starting point in my respectful submission is that what the transactional cases do is to say, if you look at them, we look much earlier on for our accrual of a cause of action. We're much more likely to pick the date on which you enter the transaction as the accrual of the cause of action in tort. See Forster, the entry into the mortgage. See AXA, the entry into the ATE insurance policies. See many of the others about effectively acting on solicitors' advice, because that's in the main where those cases lie. The starting point in my respectful submission is it's difficult, if one looks at it from a case concerning a building, to understand why, if conceptually we talk about the market value of a building being affected at the point in time that one discovers that something is wrong with it, see Invercargill, see Bank of Asia, see Murphy, effectively. So we have under the building cases the dicta which suggests that the market value is affected when one discovers the defect. What the transactional cases are saying is that actually the damage occurs much earlier on when you enter into the contract of sale. And one sees that coming to the fore in a case called Co-op and Burse, which is the sort of the collision of the building transaction world, if I can call it like that, where what Mr. Justice Stuart Smith, as he then does is he puts to one side the building analogy. In fact, as one sees when one looks at that case, he wasn't troubled by any of the building law cases that we've just been looking at all. And I understand the reason for that was that, in fact, as we'll see in a moment, nobody had a proprietary interest in the building. And as I say, we'll come look at it in a moment. But he puts the analysis that would apply if one looks at it from a Murphy perspective or an Invercargill perspective to one side. And he says, when a main contractor enters into a contractual chain to build a building for an employer, and his subcontractor, his engineering subcontractor produces a defective design for him as a main contractor, the cause of action accrues upon his reliance on the design by handing it over up the line to the employer, even though the damage hasn't been discovered or even eventuated at that point in time. So there's a real tension between the authorities that we just looked at and the authorities that I'm going to suggest we start to look at after the short adjournment.
Would you like to pause there?
I think that's a sensible point of causation.
Certainly. Thank you very much indeed. Very well. 2 o'clock, please.